News in the Karen Reid case. John O'Keefe's brother is filing a civil wrongful death lawsuit against Karen Reid.
Oh my God!
And the two bars in Canton, which she and O'Keefe visited in the hours before his death. Paul O'Keefe is filing the suit on behalf of his family. In the court paperwork, the family accuses Reid of hitting and killing John O'Keefe and alleges that the bars overserved her.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay. How is everybody? My guest today is Tom Mortati. He's a returning guest, one of my favorite guests, and he's worked in the civil defense litigation as a lawyer for over 3 decades. Mr. Mortati has tried nearly 100 cases to verdict in courts in over 20 counties and has won multi-million-dollar settlements as a civil attorney for plaintiffs in exactly the kind of cases that we're going to be talking about today. But it was his work representing the village of Potsdam in New York in Nick Hillary's lawsuits against the village of Potsdam that preceded his trial for the murder of Garrett Phillips that brought Mr. Mortati to this show and to wider knowledge of the public's wider knowledge in the case against Garrett Phillips on HBO. Mr. Hillary was ultimately acquitted for that crime. Welcome, Tom Mortati.
Hey, Roberta, pleasure and privilege to be back.
It's a privilege to talk to you. So you had this really unusual, I guess, how unusual, well, actually, that's a better question is, how unusual is this situation? We're talking about Karen Reid today. She's going to be retried for the murder of police officer John O'Keefe, but she has been in January, but now she has been hit with a civil suit by the O'Keefe family for wrongful death. So how unusual is it that these civil cases precede a criminal case?
So in general, it's pretty unusual. And just one real brief aside for a moment. So you were talking about my background. I was 26 years on the defense civil side of the world. And then the last 7 years have been on the plaintiff side of the world. So, to have a true civil case come before any of the criminal involvement from the criminal justice system is very unusual. Not quite as unusual here in this scenario where we had already one trial. You had the mistrial that was declared. There was a recent decision on, the trial judge in Massachusetts in the criminal case denied the motion to dismiss 2 of the 3 charges, and now it looks like she's going to go back to trial on the criminal matter January 2025. And the interesting part here is that the O'Keefe family members have all filed this civil case, not just against Karen Reid, but against the 2 bars where she had been drinking that evening. That the claim against them is, that they allowed her to get visibly intoxicated. So there's a lot of parts to this thing, and happy to delve into whichever part you want to jump at first.
Well, yeah, that actually, thank you for bringing up the bars, because to my eye, that seems like the weaker part of the case, because just in my looking at the case, Karen Reid never seems to show any signs of intoxication. She seems to be able to drink without it ever really touching the sides. Are these people supposed to be psychic? You can look at the video. She never looks visibly intoxicated the next morning when her alcohol was way high. something that police officers are trained to spot.
Right.
No one says that she was so drunk.
So yeah, it's really interesting if you read the complaint. Again, this is a civil case, and what's the ultimate goal of a civil case is that you want to get monetary damages, right? So the claims against the bars are under what's commonly referred to as a dram shop action, where essentially you're saying, hey, in this case, one bar, the first place was McCarthy's, the second place was the Waterfall Bar and Grill. The argument against them is, hey, you knew or should have known that this person was intoxicated, and you continue to serve them. And we know, at least from prior investigation and video, at McCarthy, she gets there, I think it's like a couple minutes before 9 o'clock. An hour and a half later, she's served her seventh drink, and it's alleged that she consumed them all. So yeah, you honed in on what the defense argument's going to be for McCarthy's, for example, would be, hey, wait a second, she didn't even appear intoxicated. Again, the plaintiff argument would be, well, it's really kind of hard to consume 7 alcoholic beverages in an hour and a half and not be intoxicated to some degree.
Good point.
McCarthy, the second place they go to at the Waterfall Bar, I mean, according to the complaint, they leave McCarthy's at 10:40 in the evening. Takes them about 14, 15 minutes, and they go into the they go into the Waterfall together, and Karen Reed is allegedly actually carrying the last drink she still was drinking when she left the first place. And she's given, I believe they allege, one shot and one mixed drink that she consumes in the span of roughly an hour. And then she and JJ, Mr. O'Keefe, leave together, and it's sometime a little after midnight that the events in question take place back near their residence. But again, keep in mind that the curious nature of the civil world, I shouldn't really say curious, but the nature of a civil case is ultimately about monetary damages. And in this scenario, you're going to have, in theory, an insurance company that insured McCarthy's, as well as the Waterfall, and presumably Karen Reed herself has car insurance. Yes, there are allegations of intentional conduct, etc., that may affect maybe some of the insurance coverage aspect of this, but ultimately this is like your classic insurance lawsuit where a plaintiff, someone got injured, in this case unfortunately died horribly, and they're suing these various entities to say, hey, you and you three individuals or entities, the two and the one individual, you're all responsible for this person's injuries and ultimate death. And one of the curious things, if you will, about Massachusetts allows these other family members. So the plaintiffs in this case, Roberta, you have, Paul O'Keefe. Paul was John or JJ's brother. John O'Keefe III is the individual, the former police officer who died. His brother was appointed as the representative of his estate. So he's suing for the estate itself. He's suing on his own behalf. His father, John O'Keefe II, is also a plaintiff. His mother, Margaret O'Keefe, is a plaintiff, and also on behalf of JJ's niece, Kaylee. And Massachusetts allows for immediate family members to sue for their own grief and loss, on top of, JJ himself, who obviously suffered these grievous injuries and ultimately succumbed to his injuries. So, this civil case is going to wend its way through, Massachusetts Superior Court, where, most civil cases are going to be filed in Massachusetts. And then you have this companion criminal case that, already played out to, unfortunately, a mistrial if you're on the prosecution side. And on the defense side, of course, they were probably very happy with the mistrial, at least because she didn't end up going to jail, at least not yet, right? So there's a lot of things that are going to happen here in both actions. So in terms of the criminal, we know, or at least based on the press reporting, I think it was 3 days ago or so, that the judge denied the defense motion to dismiss at least 2 of the 3 criminal charges, because the claim was that while the jury was hung, supposedly they came to an agreement on, I believe, the second-degree murder and leaving the scene of an accident charge. Allegedly, they had unanimously agreed at not guilty on those. But they had never reported that apparently to the court. So it's not really a verdict. And that's basically what the judge said was, yeah, I can't dismiss those charges because the jury never actually informed the court that we have a verdict on these. So you got a January 2025, at least according to press, trial date. And the interesting thing about that is, this incident occurred early morning hours of January 29 of 2022. Massachusetts has a 3-year statute of limitations on wrongful death claims, which is part of what this case, the civil case, is about. So you got a criminal trial coming up in January 2025, which would be, right around the 3-year anniversary, as well as that 3-year statute of limitations coming up. So I guess, the attorneys for the family probably decided, now it's as good a time as any. We don't want to wait too long to get too close to that statute of limitations expiring. It also, not to go on too long, but it also opens the door to various discovery things that can happen in the realm of the civil case that probably wouldn't happen in the realm of the criminal case, which may or may not become useful to either the prosecution or potentially the defense, in a criminal trial. And one other thing about that January criminal trial date is the defense, again, the criminal defense team has said, well, we're going to appeal the judge's denial of that motion to dismiss 2 of the 3 criminal charges. So there's the potential that appeal may adjourn or delay the actual criminal proceeding. So that was probably another factor in the plaintiff attorneys in the civil case, the family attorneys, minds of, hey, maybe we better just go ahead and file this civil case now and start that ball rolling.
Okay, I have so many questions for you, Tom.
Sorry, I went on a little too long there.
No, not at all. It's fascinating. So Murder by Maestro is asking, isn't a civil suit normally more successful after the criminal trial ends?
So a very good question. Just, you always have to remember in the civil realm, the standard of proof, that's required, criminal world, it's, beyond a reasonable doubt. That's the same, across all 50 states. In the civil realm, it's typically a much lower burden for the plaintiff. Again, the plaintiff in the civil case is, like the prosecutor in a criminal case, except they're not pursuing a criminal charge, it's a civil claim. And the standard of proof is, typically preponderance of evidence, or really what it boils down to in the civil world is it more likely than not? It's kind of like a 51% to 49%. If you believe one side, the plaintiff side, just a little bit more, it doesn't have to be 90%, can be less. If you believe that a little bit more than the other side, then you have to find for the plaintiff. So yeah, civil cases have a lower burden of proof. That doesn't necessarily mean they're going to be successful. That's, a whole nother issue. And the practical nature of civil cases, and typically and particularly when there's insurance companies behind the different entities that are being sued, is a lot of times these cases get resolved long before you ever get to an actual civil trial. It's actually somewhat rare. I don't know what the exact statistics are these days, Roberta, but something north of 90% of all civil cases never see the inside of a courtroom, meaning they don't go to trial. They either get settled or dismissed or negotiated in some fashion or another. So good question, though.
Wow. So I just want to thank Byron for gifting 5 memberships. Thank you. And B. Tim's asking, thank you, B. Tim. Will the TV interviews be let in for the civil? So Karen Reed gave all these TV interviews, gave a few TV interviews, not all these, a few. And then she gave some during court. One most notably or memorably to me, where she denied ever loving John O'Keefe. I think the jury will love that. And can she plead the 5th for self-incrimination? Great question.
So yeah, I'll take that 2 parts. So let's start with the pleading the 5th, the first part, because Karen Reed has certainly her constitutional rights and privileges that she can assert. typically what would happen in this scenario with a civil case pending now while there's still criminal charges is she's not going to be giving a deposition in the civil case anytime soon. In fact, what more likely than not, as I see this playing out, would be whatever appeal her criminal attorneys file in relation to that most recent court decision, which likely delays a January criminal trial, only until such time as she's gone through the next case. Let's assume she gets tried, whatever, in June of next year, right? And she's acquitted. All right. Then there's no risk of double jeopardy. There's no risk for her. She's going to have to testify in a civil case. And at that point, she wouldn't be able, there's no privilege to assert anymore because there's no risk of prosecution. If she's convicted, she's not going to be deposed anytime soon because she will likely, almost assuredly, file various appeals. I'm dealing with the exact same scenario here in a case in New York. I was one of the plaintiff liaison counsels and lead counsel in the Schoharie limousine crash case where 20 people died in a limousine crash back in October of 2018. There were civil cases filed against the limo company as well as the company that serviced the limousine, which was the Mavis Tire Centers. A number of the cases were settled. As to some of the Mavis defendants, we can't talk about the specifics for various reasons, but the civil case against the limo company owner is still ongoing. He was convicted in criminal court earlier this year, as I recall. He's got appeals pending. So in my case here in New York, we're not going to get to depose that guy until he's exhausted his appeals or gets out of jail, whichever comes first type thing. And I think the same thing ultimately is going to probably happen with Karen Reed. Again, if she's acquitted, then great for her, right? And the civil case can proceed. But if she's convicted, you can be assured of the fact that her attorneys will file appeals on her behalf. Whether they're legit appeals or not, they're going to file them.
Right. Got another another question from B. Tim. The car insurance won't rep her because Karen Reed's statement was she never hit him. Will she have to pay for her own defense? You mean civilly? I guess so, right? She'd have to pay for her own defense.
So
She's
just
claiming
because
she
she
never
might have said she
hit him.
didn't hit him doesn't, if the allegations of the complaint are that you're operating a motor vehicle and in the course of that operation of the motor vehicle, you injured somebody or killed them, typically that's enough to trigger coverage under the car insurance policy. There may be, for all I know, there may be some exclusion that applies in Massachusetts potentially with operating it under the influence, maybe not, but typically as long as you have the allegations in your complaint, which they do here, it doesn't matter if she said, hey, I wasn't driving it, or the police made the whole thing up, or whatever her claims are as to why she shouldn't be held responsible. But usually you're going to have coverage under your auto policy, and your automobile insurance company, whether that's Geico, Progressive, whoever, they're going to go out and retain civil defense counsel to represent her in the civil case.
So, it doesn't matter. She says she didn't hit him. The
Right.
evidence, Taterbug asks, will discovery be more enlightening? Meaning, and I think this is what Taterbug means. Can you go in more areas? Can more things be brought in a civil case than they can in a criminal case? It's a pretty good question. I mean,
Yeah. So generally speaking, yes. I mean, first of all, in addition to in the future at some point deposing Karen Reed, they're going to take testimony, that is, deposition testimony from the different employees at different bars, potentially any other eyewitnesses. And, these depositions can be, several hours long, hundreds of pages when it comes down to it in a transcript. A lot of times they're videotaped. So just in that scenario alone, you've got a lot more you can work with as far as from a discovery standpoint. Again, there's going to be Massachusetts court rules that apply to the conduct of discovery and the breadth of that discovery. But generally speaking, in the civil world, you get a little bit more free rein as to the things you can do. There's going to be, before they ever get to depositions, Roberta, there's what we call written discovery, where the attorneys on the different sides are to exchange different requests for information. Some of those can be in the form of written questions, sometimes called interrogatories. Some of them are either, sometimes they're called a request to produce or a notice to produce. And that's where you're asking, the other side to produce various either written or electronic documentation. Could be videos, could be photos, could be text messages. There's all kinds of stuff that you can ask for in the civil realm. And by the way, just to comment back on somebody else's question earlier about the TV interviews and stuff, she can absolutely, once you get to the point of actually deposing Karen Read, you can absolutely use any of these prior video interviews, whatever, and essentially cross-examine her at a deposition someday about the different things she said. Even if it was not video, if it was just a supporting deposition submitted to the police or something along those lines.
Yeah, and you have some experience with taking the fifth. When you deposed Nick Hillary, didn't he take the fifth? So it's crazy amount of times. It was in the hundreds,
Well,
I'm sure.
it wasn't so much as he took the fifth as his attorney. I made various objections on relevance grounds. Interestingly enough, the one thing he never did was to take the fifth. At least during the 2 times I took sworn
Oh, he said he
testimony
didn't
from him.
recall. He said he didn't
Yeah.
recall. Like,
Oh,
that's
yes.
that's what I'm confusing it
Yeah,
with.
yeah.
Okay,
I
my
don't recall
apologies.
was
Yeah.
all kinds of stuff he didn't recall, and practically didn't recall his name if I recall. But anyway, I'm getting a little far
Yeah.
afield.
Yeah, that's what I was confusing it with. I was like,
Yeah.
yeah, there was some sort of roadblock in that one. That was Tom Mortati did one of the most brilliant depositions, most brilliant I've ever read in that case
Thank you.
of Nick Hillary. Let me see. How long will this take to come up? Well, you'd have to be Nostradamus, wouldn't you,
Oh boy.
yeah, you just never know with these cases, I would think. You
Yeah, I
just
mean,
can't know.
you've got the criminal stuff to resolve typically first, again, because one of the defendants in the civil case still has this criminal case against her and has constitutional rights that she can assert if she so chooses. And I would be shocked if her attorneys didn't instruct her to do that, or basically tell the other side, yeah, well, she's never going to get deposed until all these potential criminal charges are resolved in one way or another. So honestly, Roberta, I have no clue. This thing could drag on for a while again, because, again, assuming she gets convicted at some point of something, she's going to appeal it. You can bet your house on it. I mean, that happens in just every especially high profile criminal cases like this one.
Okay, this is I guess a controversial question from B. Tim, but I think what he's asking is it's based on the complaint. It sounds like it was stating that Karen Read used people like Turtle Boy. This is something that really, you commented on my Facebook post. I think in the middle of this trial, I was just so sick of what the lawyers disgusted with what the lawyers were doing. I put up the Shakespeare quote, kill all the lawyers.
Yeah.
Except you, Tom. Except you. You get a but
somebody's got to represent somebody.
Right, exactly. I understand, but this was really what they were doing for Karen Read was they were leaking out things through Turtle Boy. They had this relationship with this blogger, and they would leak out their own evidence and then use their own leaks in their motions as evidence that it was reported on in the press. And that just disgusted me. So Tim is asking, do you think that people that pushed Karen Read's narrative or lies, says Tim, for views could be deposed? Could they be deposed? Someone like Aidan Carney, who has his own lawsuit, 19 counts of witness intimidation in this case, connected case. Could he be brought in somehow into the civil case? It's getting kind of crazy. But
Not so much brought in terms of presumably as a party to the lawsuit, meaning the only other parties to the lawsuit could be a potential other defendants in some sense. But if these people did comment on it or otherwise push these things out, in theory, the plaintiff attorneys could subpoena them for what's called a non-party deposition, and also in that subpoena say, hey, we want you to produce any documentation, whether it's in paper or electronic format relative to all of those issues. and try to delve into that even further. And it's possible that they could be deposed in the context of that civil case. Again, I don't know if any of those people are in Massachusetts, because again, this case was filed in Superior Court, Massachusetts. You can take depositions in other states. It's a little bit convoluted, but it's not impossible. It's done under the Interstate Discovery Compact, which most of the states have signed on to. So even if they're located somewhere outside of Massachusetts, you can go do depositions of people, and that could be very interesting, as far as, where did some of this information originate, and if they're able to trace that back to, Karen Reed, or, potentially her representatives or whatever. Who knows where that ends up? So that'd be
Right.
really interesting to see.
That's what's alleged in Aidan Carney's lawsuit, is that
Mhm.
Karen Reed was leaking these things directly to Aidan through the discovery, through the messages. First, she had a intermediary, and then,
Yeah.
directly. So what I'm thinking, of course, is probably the most famous civil suit, wrongful death suit, which was against O.J. Simpson. I guess in my mind it is.
Mhm.
And that came after there was really a very controversial acquittal of O.J. Simpson. Do you think in any way that this could be some kind of insurance, that if that maybe, does this show any kind of insecurity on the family's part, or is this just strictly about money? I mean, what do you think? I mean, is this some kind of assurance that she pays somehow for what they feel is her responsibility in the death of John O'Keefe?
So it's, I think first and foremost, it's about responsibility and accountability. Any plaintiff's attorney, me included, whenever we're suing somebody, we're looking for that defendant or the defendants to be held accountable for their wrongdoing. Again, I talked about how there's likely insurance companies behind some, maybe all of the defendants here, which will play into how that accountability plays out in the end, in terms of, is there eventually a payout? But ultimately, it's going to be about trying to hold not just Karen Reed, but certainly the bars accountable. But I think in large part, as I read this complaint, I know Karen is named last in terms of the list of defendants. You had the different entities of McCarthy's, then the Waterfall, excuse me, and then Karen Reed. But I think in large part, this is about going after Karen Reed, and one way or the other saying, even if these bars somehow get out of this thing, we're coming after you for our pound of flesh, because we think if you're not held criminally responsible, you should be held civilly responsible for the injuries that were caused to not only JJ, but by extension, the loss and grief that the immediate family members suffered.
So you don't think that there's any? What I'm most interested in is Karen Reed's deposition, and you don't think that her lawyers will let her schedule that until the end of her criminal trial?
Yeah,
That's
it would be shocking to me if her criminal attorneys were to allow a civil deposition to proceed at any point before either she's acquitted in a criminal trial or convicted and her appeals are exhausted, so there's no longer any issues as to double jeopardy. So I'd be very surprised, Roberta, if you see a deposition in the civil case for a couple of years at the rate I think things are going to go. That's my best guesstimate.
Wow.
Be
So this
curious
is
to
going
read
to
it, though, I
be.
tell you.
That's what I'm most interested in, is what Karen Reed would say. We just heard a radio interviewer say that the crux of her defense, that there was this kind of beef between Colin Albert and John O'Keefe, was total nonsense and made up. And
Yeah.
I don't know where you heard those rumors, started by me, but in my opinion, started by Karen Reed herself, according to what's alleged in the lawsuit against Aidan
Mhm.
Carney. But she's
Yeah.
like, I don't know where those things came about. I don't know who made those crazy lies up. So looks like she's going for a totally different criminal defense second time around, which I think looks like it. It may not be. This is just speculation, but just by
Yeah.
that interview, it looks like so I'm very curious what she would say, and she's contradicted herself every interview she's given. So, which is why I think they stopped. Murder by
Yeah,
Maestro has
exactly.
another question. Right. Are you following this case? I know, have you been following it at all,
Probably not
Tom?
as closely as you, but I've been following it just in the news in general. Like I wasn't. I'd heard about this the Aiden issue, but that was really secondary. Basically, I remember hearing quite clearly the original trial, and if memory serves me, was this the one where either shortly after the trial, like there were pictures of her and her attorney out in a social setting or something like that?
Yes, that's very nicely
Yeah.
put. Out in the
Well,
social setting, the married attorney, Alan Jackson, with
yes.
his hand on her breast. Of course,
Well,
all her they say it's photoshopped, all her supporters, but
I'm
I
sure they
don't think
did.
that I think that's even been disproven by her supporters.
Yeah.
So, Murder by Maestro's
Uh-huh.
asking, what about Karen's family? So I guess can they be brought into these depositions? Say, for example, her brother, who is alleged to have given Aiden Alexis, or her parents
Mhm.
have could have been allegedly tampering with evidence, hypothetically speaking, alleged. I'm trying to protect you, murder by Ventures. Alleged to be tampering with
Right.
evidence. Could her family be brought in? Clearly, they went and got her car right away with her.
Right. So
Uh,
yeah, I mean, not as a defendant per se, um, because again, the claims in this case, just to go through what's actually pled against the Bars and Karen Reed, are wrongful death claims, negligent infliction of emotional distress claims, as well as intentional and/or reckless infliction of emotional distress claims. So those are limited to those defendants, including Karen. However, when with all of these other surrounding issues, what happened to the car, retrieving the vehicle, all those types of things. Yes, those people can be served with non-party subpoenas and they can be deposed in the realm of the civil case. What did you do? What did she tell you? In fact, you could, in theory, and it depends on what the civil court will allow, but discovery, at least as to the non-criminal defendants, meaning not Karen Reed, and any non-parties, in theory, can go forward. We had that with with the Harry Limo crash case, where we were pursuing discovery against other defendants. All during this time that the criminal charges were wending their way through against this gentleman, Mr. Hussein. So yeah, that's going to be a very interesting thing if the family members get subpoenaed for non-party depositions, and what information did you pass to who, what did you do with the car, all these things can be in play in discovery in the civil case.
I just put up the picture of Alan Jackson with Karen Reed, socializing, as you say, with Karen in a social
In a
setting.
social setting, I didn't know how else to say it.
Only a lawyer can say that. That's so perfectly put. So perfectly put. Um, she, so, do you think that they should have brought this case sooner? Do you think this was the right time to bring this case? You talk about stats. Is it too close to the statute of limitations? And how much does that influence it at all? I mean, just as long as it's under it, is that
So, I
okay?
mean, listen, it's too close to the statute of limitations is when you're trying to file it like the day of or the day before it expires. I don't think this was too soon by any means. I think the thought process on those attorneys probably was, let's wait and see what happens with the criminal, and then what happened, right, with the mistrial and whatnot. Now it's like, okay, now we got to do something between now and our 3-year wrongful death statute of limitations. So whether they filed it in August of this year versus September or November, December, it really doesn't make much difference, because again, ultimately, it's going to be the criminal case and the appeals and whatnot from that are going to pace everything else that happens here, at least as to Karen Reed, because again, she's the only one who has, a constitutional privilege that she can assert, against self-incrimination.
So, as someone who's been on both sides, worked extensively on both sides,
Hmm.
plaintiffs and defendant side in these civil cases, if you were on the plaintiff side representing the O'Keefes, who would be, and just in the allegations against Karen, or the chart. Is it the allegations? Is that the right word for
Allegations,
it?
yep.
Yeah, allegations against Karen. What would be who would be the people that you would be most interested in speaking to? I mean, I don't. How would you be looking besides Karen? I mean, who would you be looking? The people who were with her that night.
So, yeah, you want eyewitnesses to the drinking, the service of the alcohol, what she was doing, what she was like that night. I would want to depose the family members as it pertains to the car. And, there's allegations in the complaint that concern, Karen basically at, I think it was 4 something in the morning, waking up her niece and talking about having run over JJ and all that stuff. So, any of the things that she was doing in the early morning hours and even afterwards, I think are ripe for discovery. Certainly, you're going to depose various representatives of the bars, both. And those witnesses, by the way, so bartenders, bouncers, whoever, anybody that saw her, and obviously there's going to be video from those institutions or places rather. Those depositions can be both beneficial towards the plaintiff's case claim against the bar as well as potentially against her. So there's a potential to depose a whole lot of people from the civil side of this case, and a lot of work for her attorneys to do, and figuring out who to depose and in what order.
And any statements that the family, and if you were representing Karen Reed, how would you craft a defense in this case?
Oh boy.
Little tough, right?
That's a tough one. How would I defend Karen Reed? Well, one is I'd make sure she doesn't give any statements to anybody anymore, anywhere.
Good idea. Very good idea.
But ultimately, Roberta, it's a tough question, a really good one, but a tough question because she's come out with so many different things that are contradictory of her own arguments, and then again, she's made through her people or whatever these arguments about this cabal, if you will, conspiracy in the police department, et cetera, that once you throw things like that out there, it's really hard to get out from under that, shall we say. I mean, because you're asking a jury ultimately in a civil case to believe that all this stuff against you was BS. You weren't even driving the car, and maybe I had a couple drinks, but I really wasn't drunk. When we know from at least video and whatnot that what do we have 9 drinks in the span of about an hour, 2.5 hours or so. I mean, again, everybody certainly reacts to alcohol differently, I suppose, but that's a lot in a short period of time. And I'll be very honest with you, I'd rather be the plaintiff's attorneys than the defense attorney.
Right. Yeah, definitely. I mean, you could just see in the criminal trial, there were so many. It took weeks to get all the defendants for the Commonwealth, and then just a couple of days for the defense. Casey Jacobson, any reason why there's no that it's not representing the nephew? Is it because he's underage as part of the estate? Is he part of this case?
I don't believe. Are you looking at the actual caption of the complaint? It was the last listed plaintiff is Margaret O'Keefe, who's JJ's mother and grandparent / guardian of Kaylee, a niece. I don't know how old Kaylee is or was at the time, and I don't know the age of the nephew. I don't know why the nephew was. I believe they reference him in the complaint by name. Actually, it says here they were 6 years old and 3 years old, respectively. I don't know who the guardian is.
When their mother died and they were given guardianship of the
That's
O'Keefe
what I
family.
think. Yeah. So, and I don't know how long ago that was, but it could very well be that if somebody else was the guardian. I don't know the reason why.
Yeah, I think she was 15 or 16 at the time, and he was, however, you do the math, however much younger. Or is she 15 now? I'm getting confused, guys. If you guys know in the comments,
Yeah.
let me know if she knows, how
So
old she
one of
was
your
in
listeners is going to know the
1922.
answer to that.
I know, I'm getting confused because both times they were minors when they testified. They were minors this year when they testified.
Yeah, and
But
I know it
it's
alleged that
interesting why
JJ took custody of them. Um, I mean, let me pull it up. Yeah, paragraph 9 of the complaint talks about they were 6 and 3 when he took custody, and over the next 8 years until his passing, it says he raised and supported both his niece and nephew. So I don't know why the nephew's not a party, if you will, the same way in which the grandmother, Margaret O'Keefe, JJ's mother, is acting on Kaylee's behalf.
Thank you, Susan Hicks. So she was 15, Kaylee, and she was 13,
Okay.
I believe, at the time of the
Okay.
John O'Keefe's. I don't know how you would say alleged murder. Let's put it that way.
Yeah.
So, is there anything else we missed here? I mean, I just think it's all very interesting. That's why I came. Thank you for doing this. I just thought it was just a really interesting turn of events in this case.
It is. I
And
mean, whenever you have, you reference the OJ case, obviously, perhaps, the most famous, if you will, where you had a significant, huge criminal trial. I mean, the publicity at the time was beyond insane. And then followed by the civil case. So, this case certainly maybe not quite as insane publicity, but it's way up there. And there's going to be some stuff that's going to be uncovered, and if the plaintiff's attorneys for the O'Keefe family do what I think they might do as far as depositions of various other people, there's going to be some interesting things that I think will ultimately come out in the context of that. Again, it may not be for a couple of years, but I'm really curious to see how it plays out.
yeah, me too. And I know we're just winding down, but could the bartenders take the fifth? They can take the fifth, right? If they're deposed, they can take
So
is it just
I
Karen Reed?
I don't know what criminal charges could potentially be asserted against them, and I don't think anyone's ever even suggested as much. So typically, I mean, we in the course of both my defense career and my plaintiff's career, I had defended dram shop cases. I've prosecuted them as a plaintiff attorney. I've never had a bar employee, whether bartender or bouncer, or anything along those lines, assert the fifth. Um, I don't think that's really anything to worry about. I don't think it's going to be an issue at all. I think there'll be a typical deposition, and they'll be asked the usual questions, and they will be deposed as any other witness in a civil case.
One last question from Cynthia Doolittle. Can the information from Aiden Carney, aka Turtle Boy's trial, be used in either of her trials?
So very good question. So you got two issues to deal with in terms of what information is developed in the Turtle Boy case. First is going to be relevance, and the second is going to be admissibility. And if it's relevant to one or more of the claims in either of those two trials, and it's admissible information for purposes of either of those trials, then it could be used. But you got a twofold test, if you will, of whatever that information is. But in theory, it could be, yeah.
Kathy Barella, wow, what are the repercussions? So if Karen Reed is found guilty and the civil case is ongoing, well, obviously you said she's going to be in her appeals and it will delay it. But besides that, what are the repercussions if Karen Reed is found guilty while this civil case is ongoing?
So
Kathy's
it's
asking.
certainly not very helpful for her defense in the civil case. Again, while the standards of proof are different, there are higher standard of proof in the criminal world, and the charges are certainly different. In the criminal case, this is a manslaughter. There's leaving the scene of an accident, and there's a murder charge. Assume, for the sake of argument, she gets convicted on all three, and assume all of her appeals ultimately are exhausted. That can become evidence potentially in her civil case. The reality is it's going to be very difficult for her attorneys in the civil case to overcome that conviction. And, again, by that point, with all her appeals exhausted, she's going to have to testify. And boy, that's going to be one heck of an interesting deposition, and a long one too, because there were so many statements that were given. There were so many, for lack of being generous here, alternate theories that the defense has proposed,
Right.
all of which has become fair game in some sense in a civil deposition. Whether it, is worth that pursuing that in terms of the ultimately in a civil trial to be determined. But it's going to be an interesting deposition. I see there's another question that just popped
Yeah.
up.
Can Karen Reed be sued for more than what her car insurance covers? And can they freeze her assets, such as the sale of her home? Her home has
So
recently been up for sale.
yeah, two good questions. So first of all, anybody can be sued for more than whatever their car insurance covers, right? So everybody buys car insurance. They're going to have some limit of liability insurance that they have selected and paid for. A lot of people are underinsured sometimes if they get in a bad car crash and cause really bad injuries to somebody, or death like here. So yeah, she could be in theory sued for above and beyond whatever let's just say she has a $500,000 what we call bodily injury policy limit on her car. She could be sued for, and they could get a judgment for well above that. When it comes to going after assets, personal assets, generally speaking, I don't think you can go after someone's primary residence. That's just a general rule as I understand it. But any other potential assets she has, can you can pursue those. But when you get a judgment against a defendant in the civil realm, enforcing that judgment or collecting on that judgment can go various paths. If somebody's got a job, you can garnish their wages over a period of time and recover money. And there's various other things you can do. It's a long process, though.
So, so we know that Karen Reed isn't the only one in this suit, but if Karen Reed files bankruptcy, B Rabbit's asking, does that end her part of the case, her liability in this civil suit?
So no, I mean the weird thing about the bankruptcy part is you really typically only see a defendant in a civil case that files for bankruptcy where there's a judgment, like there's no judgment against her right now. No one can collect any money against her from a civil standpoint in relation to these claims because it's simply just a claim at this point. Typically, you might see that. Again, let's play this out. She's had her criminal trial, presumably whether she's acquitted or convicted, and her appeals are exhausted and all that stuff. And it's 2 years, 3 years from now, and there's a jury verdict in a civil case. Let's just throw a number out there. Doesn't mean anything, but what, a $5 million verdict, right? In theory, at that point, she could file for bankruptcy, and then it makes it very difficult for the plaintiff attorneys to pursue her for, any individual recovery, above and beyond, again, potentially any insurance coverage. And that's typically where you might see that come into play in this type of scenario. I really don't see that coming into play beforehand.
So, very interesting questions from Rena and Renee Mason asking about anything that was basically raised for her defense, or the amount of revenue that Turtle Boy made from this case. Could that be part of her civil case? I wouldn't think so.
Wow, that's a really interesting question. My gut reaction is no. While in theory, I suppose if they were subpoenaed for depositions in the civil case, that would be potentially an area of inquiry, excuse me. But again, even in the civil case, while the scope of discovery is generally fairly broad, ultimately there's some guide rails on either side of everything, and those guide rails are relevance. And what is the relevance of that to the individual claims that are set forth in the complaint that was filed? Again, you got claims for wrongful death, claims for negligent and intentional infliction of emotional distress in relation to the injuries that JJ sustained and his ultimate death. Some of these other things are potentially extraneous and irrelevant to those specific claims set forth in the complaint. So I don't know that they'd be able to get that far with it.
Okay, I've held you way too long, way too long.
What time is it?
Tater, it's almost an
6.
hour. We've got to, but this
That's all
is,
right.
I think we've done it. But I know the audience has been super appreciative and interested in everything you have to say. I know Taterbug, you're asking if they've gotten a guilty verdict, if they've gone after for, but that's a criminal question. But do you have an opinion on that? Do you think that
I'm sorry,
they
what
should
was
have
the
gone?
question?
If they would have, sorry, I just sort of skipped over it. Would they have gotten a guilty verdict if they've gone after her for involuntary manslaughter rather than premeditated second-degree murder? I mean, that's kind of a
I
criminal.
believe one of the 3 charges was manslaughter. I don't know if it was involuntary or how they term it in Massachusetts, but she pled not guilty, according to the news reports, to 3 charges, which were second-degree murder, manslaughter, driving under the influence, 4 charges, leaving the scene of a deadly crash. So again, I don't really know the answer to that one in relation to the specifics of the language of manslaughter. And that's a whole nother, would they have had a guilty verdict or not? I don't know.
Yeah, it's just been I've never seen a campaign like this for a criminal defendant ever, and the news media really joining in on it. So it's going to be, I think, a tough going the second time around. Thomas Mortati, thank you so much for this interview. It's been fascinating. I appreciate your time and
Roberta,
your knowledge.
pleasure and privilege to be back, and happy to talk to you again in the future sometime again.
Okay, thank you so much. Thank you, Rena.
Take care. Bye-bye.
Bye.